Sobel, and I'm a real estate attorney here in Michigan. Today's question concerns a mortgage foreclosure on a commercial piece of property. Just so you know, commercial property like residential property can also be foreclosed upon. So the question comes from Scott S. of Shelby Township, who owns a restaurant and the building as well. And he states, I got to get this right here. He states, I've received a notice of foreclosure from the bank 3 months ago, but the building has already gone to foreclosure sale. I don't think that the balance as stated at the sheriff's sale is correct. It is higher than the figures that I have calculated. So then he writes, much more than what I thought I owed. So he calculated the figures differently than what the bank has calculated. So his question is, what can I do to bring this to the attention of the bank? And who do I speak with? He also asks, is it too late? Well, Scott, your question actually has multiple issues. Of course it would, because this is law. Anyway, so the first generally is that it's very important that when you receive an initial notice of foreclosure, usually there's one or two, but when you receive your notice of foreclosure, it's also known as a notice of default or NOD, that you verify that the amount that they state on the NOD is valid. Is it consistent with what you believe? Also, you have the opportunity to demand from the lender or the lender's attorney a validation of the mortgage obligation. And that's called a validation of debt. And what this means is that you have a legal right to request the evidence to show that the lender conducting the foreclosure sale is actually in the legal chain of title as your lender. It's very important. This tripped up a lot of banks and lending institutions during the Great Recession, actually, when they were doing foreclosures and robo-signing. Anyways, since the property has already gone to sale, Scott, it's usually a bit too late to get the attention of the lender or the lender's agent to actually recalculate their figures and stop the sale. And that really brings us to the second issue. If there are serious problems or legal concerns that you have, and the property does in fact go to sale, you must address this problem during the time frame in what we call the redemption period. So you have a redemption period or a time allowed for the homeowner or property owner or business owner to get their property back. And don't wait until that redemption period expires. So the redemption period is a time that you have to pay off the entire balance due so that you don't lose your property. In Michigan, the redemption period generally is 6 months. And there are exceptions that will extend the period out further or even shorten the time period. In those exceptions, you're going to probably want to consult with a real estate attorney just to determine if those exceptions would apply to you. But generally, 6 months is pretty standard in a foreclosure situation. So here's the thing. If you don't legally challenge or bring a lawsuit by another name before the redemption period expires, you're going to have very little chance or legal opportunity to prevail in court against your lender. And that's because Michigan courts hold that a mortgage is extinguished after the time for redemption has expired. Understand? So courts have ruled that without a mortgage left, the property owner does not have any rights to bring their matter before the court because there's just no mortgage, underlying mortgage available. There's no mortgage contract. So no mortgage contract, no legal rights or legal foundation to be in court. So your question, Scott, had a lot of good issues. So to sum this up, Scott, if you can show problems with the lender's calculations, you should be able to set the sale aside. But it's not likely without bringing a lawsuit. And this is why it's so important to respond and challenge the allegations that are contained in the notice of default or your foreclosure notice within 30 days from the day that you receive the notice. Actually, it really is 30 days from the day of the letter is dated. And you want to do that before the property goes to foreclosure sale. So I hope this helps, Scott. I'm David Sobel, again, a Michigan real estate and finance attorney. And if you like this presentation, please feel free to leave me comments on this video or kindly share this video. Also, don't hesitate to write me with your request on topics you'd like for us to cover here at Sobel Law Proven Resource. And more videos, blogs, and slide presentations can also be seen at provenresource.com. Again, I'm Dave Sobel. You can reach me at 888-789-1715 should you have any other questions, comments, or concerns. Thanks for watching.